Welcome back to Law and Crime Network. My name is Bob Bianchi. I'll be taking it from 12 to 3. Let's get right to me introducing my great guest, my Jersey girl, Linda Kenney, Baden, with some great shirt you got on there.
Good morning, Robert.
We were having a debate, the difference between a shirt and a blouse.
That's right.
The important things we talk about before we go on air.
You wouldn't believe it.
Yes, and Eddie says, and I agree, it'll be someday when we can call everything just a shirt.
That's right.
No
and you know what?
discrimination.
Eddie's in my picture that I posted on Twitter just now of you, but I wanted the people to guess his name, so I just told you his name. So the first one in could say Eddie.
Yeah, Eddie, my man. So he's always doing the right thing on hooking us up. So listen, we've got this case. I know we have a lot to talk about, right, Linda, but there was in this case, there are opening statements of the prosecution's second go around because the previous case with Elder was done. Let's go to the prosecutor's opening statement. I want to come back and ask you some tactical questions. We'll be right back. Okay, welcome back. So the prosecutor's opening statement, I got Linda, I brought you on, and I didn't even know, and usually telepathically myself and Gene Rossi are like on the same page, but I got hashtag 4041. Gene Rossi, unbelievable, prolific career, 3 decades at the DOJ, over 110 trials, 90 of which were jury trials, Linda. And Gene, welcome back to the show. I want to get to this opening statement real quick, but how you doing?
I'm doing well. Good afternoon.
Yeah, good afternoon. Oh, there you are. Let's see that pretty face. Okay, Gene. So listen, just real quick, in the previous trial, the case was severed for some reason. I'm not sure if there were Bruton issues or statements as to the reason, but...
And Bruton means one defendant can't testify.
Yeah. Well, why don't you explain Bruton first?
Okay, so Bruton is a case that says if you have 2 defendants in a case and one is given statements or they're given statements against each other, you really can't have the trial at the same point because you can't call somebody to cross-examine. So I can't call the other co-defendant to cross-examine him because it would be a violation of rights. Right,
and Gene, let's stick with Bruton for a minute. When you have that case as a prosecutor, it's a little bit of a lag on you when you have a Bruton issue because you know, as a prosecutor, you have to try the same case twice, and no prosecutor wants to do that.
No, and here's the thing with Bruton. There is a small exception. I think it's the Richardson case. If you can sanitize the statement of one of the defendants so that it doesn't refer to the co-defendant or co-defendants, you can have a joint trial with 2 or more defendants, but that's a thin needle to put that thread through.
Yeah, that's an excellent point, Gene. And you know, these guys, these issues, and for those of you in the chat room, I love when you're in there, you know, these issues are key tactical issues that make huge differences in that courtroom. And it is, again, difficult for the prosecutor to try the same case twice. But they're doing it here. But Linda, interestingly, this prosecutor wasn't the prosecutor that was on the Elder case.
Okay, so before I answer that, I just want to make one little note having to do with the blue sapphire wave. You have 2 women in the courtroom, and I love it. I don't care whether they're prosecutors and defense attorneys. 2 women lawyers. But let's go past that, you know, because my heart is in the defense in this case, even though there was somebody who was dead. Here, the defense, the state is still barred from, giving a different, well, they're not. They can give a different theory. But if there was the same prosecutor, she really couldn't give a different theory, right? Because she tried the first case. So that's going to be an issue to see whether or not the state wants to just jive a little and make a little different theory about what happened. Saying, well, we learned from the first case, that's why we're making this different theory.
Well, let's talk about that. I mean, I don't know if the prosecutor is going to try the case differently. I think it's difficult for them to do that, especially with their witnesses.
I would argue that they're barred.
Yeah, I mean, it's an interesting issue. But, Gene, listen, this first case, the defense lawyer did an excellent job. I hope we're going to have an opportunity to look at some of the summation in the Elder case because I expect you could see the same kind of summation or approach here by the defense attorneys, i.e., this was self-defense. This guy just shows up on the street to give a friendly gesture and a handshake, and there's all this previous motive. This is a hard case for the prosecution, no?
Absolutely. The visual of somebody extending their hand and then they get killed, that is very bad for the government. I did want to comment on having the same prosecutor or two different prosecutors. I think it's a horrible decision to have 2 prosecutors doing 2 different cases or trying both defendants, and here's why. When you are the prosecutor, the sole one for both defendants, you have this depth of knowledge. You have the nuances of each witness. You have consistency in how you're going to approach the case. The whole theory of too many chefs spoil the broth kicks in, and when you have one prosecutor doing one defendant and the other doing the other, I think you're tripping over yourself.
But Gene, the state basically lost the first case, right? The guy, the elder got convicted of the culpable negligence, which is a maximum year penalty. So maybe they decided they don't want that prosecutor, right?
You know what? If that occurred, I feel badly for the first prosecutor, okay? Because that the verdict against Elder, that kind of made sense because Baptista was I don't want to use the word trigger man, but he was the guy with the knife and did most of it, although the other guy did one stabbing. So that lesser included, that didn't surprise me.
Yeah, I personally think that it is a mistake. I've had cases severed as a prosecutor. I've tried defendant 1 and then defendant 2. I know the case better than anybody intimately. And by the way, that prosecutor in the previous case, I think did a very good job. I just think that she had a very difficult case. Let's go back to some more of the prosecutor's opening statement and see if we see some differences in the Armando Baptista case, the second defendant being tried. All right, so we're in the Armando Baptista case. This is the opening statement of the prosecution. They're on lunch recess now. Now, Gene, let's go back to the previous case here. If I understand these facts, somehow they're all at this party together. They're hanging out. There's supposedly an incident previous to this where Baptista cheap-shotted somebody and broke their jaw. That supposedly is the motive for this. Anyway, Baptista and Elder leave, and I think that this is the most critical fact that hurts the prosecution. They leave that party, and somehow the victim, Muhammad, just happens to be going behind them in a vehicle and at a stop sign, gets out, and supposedly on the street is this genteel handshake and a, hey, how you doing kind of thing that winds up into a stabbing murder. It just doesn't sound right to me in terms of how the world operates. Here's Baptista and Elder going away, and here's Muhammad supposedly avenging a wrong that Baptista committed by breaking the jaw of another person coming behind them. I mean, that's where I'm going as a defense lawyer. Thoughts?
Yeah, it's a square peg in a round hole. You're absolutely right. Something happened inside that party that caused the victim to get a little angry and outraged. And when the defendant and Elder left, he followed them. And that is completely inconsistent with a handshake. And if I'm the defense attorney, I'm going to mention what you just said. It doesn't make any sense that he follows them coincidentally. They have this altercation at a stop sign, and he offers to shake his hand. What's the motive for shaking hands? All right. Here's the other thing. When I did openings, I always said this. Members of the jury, the United States doesn't have to prove motive, but there is motive here. And here's what it is. I hate when a prosecutor says, we don't have to prove motive. Motive drives crimes every day of the year, and you have to talk about motive. The motive here was this. They left, Elder and Baptiste left, and there was an altercation that they left at the party, basically. Mo Knight followed them, and it escalated. And the motive is this. You got guys at a party who are trying to act like big, tough guys, and it ended up being a knife and a killing. That's the motive. That's what happened.
Right, and just lastly, because we're going to take a quick break, and I'll get back to Linda on the other end of this, and who is pursuing who, I think is the huge point to add to what you just said there. Who is leaving the problem, and who is leaving and following these guys and then having this quote-unquote genteel handshake on a street with people that he supposedly doesn't even know. Listen, that's where I'm going as far as a defense lawyer. Thank you, Gene. Linda, we'll get back to you on the other end of the break. We'll be right back. Okay, wow. This is a lot of complex law, and nobody better than Linda and Gene to help us out with it. So, Linda, tell us what a motion in limine is, and essentially what it was that each side was trying to preclude from getting out before this jury.
Okay, so think of the word limit. Motion in limine is to limit, basically, and I'm using words that everyone understands, testimony that can go before the jury. You know, and then even if you get it granted, sometimes you may change your mind, but that's basically what it is, simple, right?
Right.
Okay, so let's start with the defense. The defense didn't want any mention that Elder had a stand your ground hearing, right, or testified in the stand your ground hearing, and that the judge denied it. And the defense didn't want any testimony that Elder had been tried and convicted of the lesser included crime. So why do you want that, right? You don't want anything about the lesser included because you may want to put all the blame on Elder for the manslaughter. So you don't want to say, you know, we're bound by that. You also don't want to see if Elder had any mention to your client. You don't want to have that in there. And you certainly don't want the stand your ground hearing, which was denied. So that's what the defense did.
I found something interesting, Gene, in the recitation by the judge. And if I heard it correctly, each side filed a motion in limine to limit the result of the Elder conviction. Obviously, as a prosecutor, I don't want the jury to hear I came in with a big, bad manslaughter charge and it got dropped all the way down to this, because that's not good. And interestingly, the defense similarly didn't want to have it heard that he was convicted of anything. What are your thoughts about both sides agreeing to limit that information?
Well, there's that phrase, mutually assured destruction. Here we have mutually assured interests. They both don't want it in for the reasons you just said. I did want to add, Linda's right, motions in limine involve limiting things at a trial. I know it sounds like a non sequitur. When I was a prosecutor, I would file what I called offensive motion in limines to get the judge to rule that I can bring in evidence.
You can do that.
And it was a beautiful thing because I knew that this 404B evidence was coming in. I knew if I had 5 witnesses, I'd fly them in and they would indeed testify. I loved motions in limine, whether to keep stuff out or to get stuff in, and I wanted that decision before trial.
Linda, you know something? We got to go to something real quick. But do you know a secret? You want me to tell you a secret, just between me and you?
Yeah.
Okay.
Everyone don't listen.
Just between us, nobody listen. This is why there's a room at DOJ called the Gene Rossi War Room.
Yeah, but what Gene didn't catch is the was. Let's talk about that. The judge said the prosecutor said it was for another jury. And the judge said because she said was for another jury, it's okay. So that has implications itself.
Right. So,
Right,
okay,
Gene?
guys, great analysis, the Gene Rossi War Room. We're going to go to now the defense opening statement, because this is a case that is defendable. This is something where you could get an outright not guilty. Let's go to it. Okay, so this is the defense opening statement. As we indicated in this case, there is a defense for Armando Baptista, and that is what she is presenting. And essentially it went like this. They're at a party, the victim comes in, the quote-unquote victim. Demetrius Mr. Knight asks Armando what his name is in an awkward confrontation. Demetrius tells Armando, those are the 2 co-defendants in the case, let's go, as we talked about before, that what they didn't know was that they were being followed later by Mr. Knight, who honks the horn, gets out, goes to the passenger side of the vehicle, and attacks the defendant, Armando Baptista. Gene, I think that this is a pretty strong defense opening, because it's not about talking about presumption of innocence and proof beyond a reasonable doubt. She is making some very specific factual allegations, which, as a prosecutor, you know are hurting your case.
Yes, and here's the thing. If you compared the opening of the prosecutor and the defense attorney, putting aside what they're wearing, their attire, okay, I would say that this is going to result in acquittal or hung jury, and here's why. Usually a defense attorney is not as specific in the facts in their opening because they don't want to pin themselves to a certain version. They want to sit back a little bit. This defense attorney was very specific, whereas the prosecutor was very general, almost defensive in the presentation. And I want to bring up a key point that you brought up, Bob. Common sense supports what the defense attorney said versus what the prosecutor said.
Right. And Gene, I just want to ask Linda a quick question on that point of common sense, because I always say,
or nonsense.
And when I train people, that common sense, not sophisticated legal arguments, not convoluted, torturous logic, things that just say, why would those guys leave? This guy then come, honk a horn, have a confrontation, and get out. Come on. Get out and just go to shake hands and say, hey, how you doing?
And here's what's even more important. Remember that the victim, the decedent, got in the party late. So the theory is that, look, this was kind of muscle coming in, so
Right.
that these guys leave. They don't want to get involved in any confrontation, and that's really what it comes down to. So they're leaving, and then night follows them right there after it. And you know, I don't, again, you're right. Common sense or nonsense. Someone gets out of the car in the middle of the night or at nighttime to go, hello. Let's just shake each other's hands. Can I shake your hand? Can I shake your hand, Bob? You don't want to shake my hand,
no,
you say?
I'll shake your hand. Yeah, we were just at the other party. I was just asking you what your name was.
Right.
You decided that you and your friend were going to take off, and I just happened to be at the right place at the right time to get out and say, hey, how you doing?
And I'm coming up to you with a beer bottle.
Yeah. So okay, listen. I mean no disrespect to the family. It's obviously
It's terrible.
It's a tragedy of what happened to him. But nevertheless, if you were going to be a prosecutor and you were going to try to prove a case beyond a reasonable doubt, you got to have facts that make sense. We're going to get into the self-defense law though, and whether or not the force used was excessive against Mr. Knight a little later on. But we got to go to break. We'll be right back. Welcome back to the Law and Crime Network. We're going to take a little bit of a sidebar here, if you will, Linda and Gene, and talk about the fascinating Iowa versus Koehn case. Very sad. 28-year-old defendant on trial for first-degree murder, facing life in prison for having committed an extreme indifference to the value of human life for their little 4-month-old baby boy Sterling, who was left in a complete state of disrepair. Was only 7 pounds, 14 inches long. We've tried not to get too much into the graphic details, other than to say we'd like this to be a message to everybody out there about, if you can't take care of your child, there are so many services that can do that for you. Go to a family, go to a friend, go to the police department. But leaving a baby in this condition, maggots in various stages on the boy's body, well, the jury got to listen to all that evidence, Gene and Linda, and now they and the state of Iowa got their opportunity to respond to Mr. Koehn by way of a verdict. Let's check it out. You know, Linda, we talk about this. It's a guilty verdict, but I think it's striking to people like me and you and Gene, not that there's a rightness or wrongness to it, but the speed with which these verdicts are taken in court, which is usually a much more lengthy process, up to and including polling the jury.
Right. Usually, it's at least in New Jersey and New York, it's much slower. But you know what? In this case, quick verdict. I would have been out in a minute.
Yeah, wow.
I mean, you know, and that's coming from a defense attorney. I was so offended. And part of looking at the elements of a crime is jurors do get offended. They do get offended.
Right.
They have to keep that emotion in check, but the elements of the crime are here.
You know, Gene, when I was prosecutor and got the top job, I had to be the person that was doing the media outreach. And I learned, it was a little counterintuitive for me. I wasn't a media person, I was a prosecutor, but I had to learn quick. And one thing I learned is that the media will always be there if there's something that involves the death of a child or the killing, purposeful killing, believe it or not, of an animal. These are two areas that when I knew we had a case like that, I knew I was going to be standing there with a throng of cameras. And I think it gets to Linda's point about the emotional reaction to the jury with a case like this. Your thoughts?
Yes, and I got to compare it. I've had drug cases that I prosecuted where you had horrific murders, just horrific. But it was a drug dealer killing another drug dealer, and the courtroom is empty. But you're right, if you have a child or an animal, the courtroom could be packed.
All right, well, listen, excellent. We got more coming up for you on Law and Crime. In fact, I'm not going to even tell you what it is. We're just going to let it roll. Okay, we are here in the Koehn case. That was the prosecutor giving what I believe to be an unbelievably great created summation in the case. Gene, let me just start with you. First, we hear this act by not acting. And she goes to, really brings it home. Every time he watched TV, he made a choice not to care for the child. Every time he went to the refrigerator for a pop, also known, Linda, as a soda in the rest of the world, I believe. That's what they're referring to, not an ice pop. And get a sandwich, he refused to take and feed Sterling, the baby boy. Every time he fed himself, he neglected the child. When he went to the bathroom, he didn't change their diapers. He made a choice not to do that for 10 to 14 days. When he bathed himself, he made a choice not to bathe the baby. I think it was, she blew it out of the water and did a great job. Your thoughts?
Yes, and the key thing about what she did is, and I'm not a big PowerPoint person, but she didn't overdo the PowerPoint, make the PowerPoint your presentation. But here's the other thing, it's just globally, she had a very conversational style. And when she was saying that a choice is an act, and she showed the photo of the living room, and every time he sat down and watched football or television, he made a choice not to take care of Sterling. And I thought that was pretty darn good. I'm wondering if in the jury instructions, the judge actually says a choice not to take an action is an action.
It's an action, yeah.
Yeah,
I was thinking the same thing, Gene. I'm sorry to cut you off. Linda, what do you, I was thinking the same thing, but I can't imagine, given the endangerment charges that I've seen around the country, that a failure to act cannot be considered also an act. That sounds a little odd.
I agree with you, but you know what was interesting? It's always fascinating me with this case is that the prosecutors said that Sterling was his child. Remember, they must have done DNA testing looking for a motive as to why he would treat this child differently, correct? But does it make it better or worse that he's his child? I think it makes it doesn't have a motive, but I think it makes it worse because he's the father.
Well, we knew what the jury certainly felt, but
Yes.
listen, you got a tough road to hoe when you're a defense attorney in a case like this. So let's check out the defense's closing. All right, we're in the Koehn case, and that was the defense attorney giving the closing statement in a very tricky case. There was no defense lawyer in the United States of America that was having a more difficult day than that defense attorney, in my opinion. Linda, how do you think he did?
Yeah, but he brings up the fact that he says that there was some indication that he told his brother the child wasn't his. Why would you do that? Why would you now give a motive? I mean,
Yeah, I was thinking the same thing, Gene. Did that seem to make sense to you, or were they going for some sort of legal distinction that he didn't have a duty to the child because he didn't think it was his? That's it. I mean, I'm just trying to figure it out myself.
I agree with Linda. He did kind of give motive. Now, rebuttal, if I were to prosecute a rebuttal, I would get up and I go, you know what? We didn't have to prove motive, but we do have motive, and the defense attorney just admitted it. He thought it wasn't his child. That's motive. He didn't care about that child because it wasn't his. I do want to add this. I feel for that defense attorney. That is the hardest closing argument any defense attorney can probably make in the last 30 years, and he should not be depressed of the guilty verdict. It had nothing to do with his performance.
Right, he was doing his job, and it's by having good, effective advocates on both sides that we have the best chance at getting to a true, just verdict in a case. I think anybody who's been in that courtroom, prosecutor, defense attorney, judge, believes that. So listen, thanks guys for your commentary. Hey guys, get in the chat room, or if you don't have that Pluto app, get that Pluto app. Me and Linda listened to it before we come in here. I love it. We're going to take a break. We'll come back on the other end with some more. Okay, welcome back. We got some breaking news, at least in the Koehn case. We want to give you some updates on it because we want to make sure we're completely accurate and our viewers have everything. Not that we were inaccurate, but the defense lawyer in summation just said he didn't think the defendant, the child, was his. But in fact, during the course of the trial, they stipulated, that's an agreement between the prosecutor and the defense, that in fact it was his biological child, which makes that argument even more odd than what we talked about before. And as an update, thank you, Kathy Russin from the Law and Crime Network. We were asking about why is a new prosecutor? We have the answer. Our producers and people here are great. Elder's prosecutor, that's the co-defendant, it's in the Elder case, I apologize, last month joined the law firm dedicated exclusively to protecting abused, disabled, and injured children. So that explains the switcheroo in that scenario. Getting to the Koehn case, Koehn makes a 911 call that became a big point for the prosecution in this case. Let's listen to it and come back with Linda and Gene on the other end. All right, welcome back. Sometimes time goes faster than you even think, Linda. You know what I'm saying? So, guys, we're in the Koehn case right now. Linda's been diligently going through and scouring inside of the chat room. We got a couple of minutes before we take our next break. So, Linda, let's get one of those questions. I think Funfree had one of those questions.
Okay, Funfree had when Harris gets tried. That's the mother of the child, right? And his girlfriend, Koehn's girlfriend. Can prosecutors mention the Koehn conviction at all?
You have to repeat it for me again. I'm sorry.
When Harris gets tried, can prosecutors mention the Koehn conviction at all?
I'm not sure if I know. Gene, what do you think?
Well, in Cheyenne's trial, no,
Yes.
you can't mention that Koehn got convicted?
I think that's exactly the same issue that we're dealing with in the other trials. I mean, you would be then basically telling the jury what a previous verdict was. I don't see that ever getting in. Is that the whole question, though?
No, that's the whole question.
Yeah,
then
so
we have
there's the
another
answer to that.
question.
Thank you, Fun Free.
A non-1824 would like to know if the hospital, which detected meth in Sterling's umbilical cord, could be prosecuted for criminal negligence for failing to report it. Great question.
Well, I would say, I don't know, Gene. I think that that's a little stretch, but there got to be some reporting requirements there that they may be responsible for. But I'm not certain whether, as a prosecutor, I would take that case on criminally, although I would thump them for not reporting it.
Well, isn't it child abuse, though?
Let's go to Gene. Let's see what he thinks.
I'm sorry, Gene.
You read the question, Gene answers it.
Okay, I'm reading the
Well,
question.
Linda knows that she's going to be hosting after the show. Go ahead.
Yeah, right, Linda. And Linda, I still love your glasses.
Thank you.
Here's the thing. When I was a federale prosecutor, I prosecuted doctors, pharmacists, nurses. It is very hard to prosecute medical professionals. Very hard to go after anybody who's at a hospital criminally. Now, negligently, civilly, that's another issue.
Yeah, absolutely. I agree. But what do you have thoughts on that?
But yeah, I have thoughts in this way. I mean, if you're taking meth, right, and you're a meth head, and you're giving birth to somebody, the likelihood, whatever it is, you could give birth to a child who's addicted or whatever. But if there's meth in the umbilical cord, isn't that child abuse?
Yeah, well,
I mean, I would take a broad view of this in New Jersey.
It was funny because you're usually on the very, very liberal defense pieces of these things. But I'm not saying that it's not something that should be reported. It's not something that should be looked into. I'm just telling you, as a prosecutor, I am not going to prosecute a doctor or a nurse or somebody who had knowledge of this for their failure to have brought it forward. I just wouldn't bring that. You would kill me as a defense lawyer if I did that.
I agree with that, but don't they have a duty to at least report it to a child abuse case?
I think
did they?
Yes, and I think it's a great question because it's actually a public service question. They should be reporting these things, and if they were supposed to and they didn't, they should be sanctioned for that, maybe even sued civilly for that.
We don't know.
But we don't know. Maybe they did, but that's an excellent question. Listen, we are with two great guests. We love when you guys get in that chat room and you ask questions. If you have family, friends, bring them on board. I got Linda and Gene with me. No two better people to break down a case like this. We are at the Law and Crime Network. We're going to be coming back with these guys for a little bit more on this case and some other stuff. Stay tuned. All right, welcome back. That's the police officer looking over his shoulder at a video of his then body cam speaking to Koehn, the defendant, right after they found the 4-month-old boy Sterling dead in a complete state of disrepair. Gene Rossi, it's not even brain surgery. There's something very visual that's popping right out in that video. It's not talking specifically in words, but it's speaking loud and clear to the jury.
Well, what's speaking to me is this guy's a manipulator. He's holding his 2-year-old daughter, talking to a police officer about the death of Sterling, who's 4 months old. Our first child was a daughter. I would never do that. This guy is a weird person with no conscience.
Right, and Linda, I think that there's some value. I mean, I say value. You hate to talk in terms of it, but as a prosecutor, that there's the child in the room over there, in the manner in which that child was, and there's this 2-year-old right here that seems, to the extent that you can see from that house and the way it looks and these kind of folks that we're dealing with, to be well taken care of, at least.
Absolutely, yeah. I mean, look at her. She's moving around. She's got weight on her. Her hair is done. She's got a nice dress on her. So that's the issue. All of a sudden, you have a young girl. This 2-year-old is taken care of, right? So the mother has postpartum depression. I don't know if that affects her taking care of the 2-year-old or just the infant. But here, the father's taking care of one of the kids, but not the other.
Right, and when you talk about all the things, Gene, that you can with the constellation of defenses, whatever they may be, it's really hard to explain in my mind how that 2-year-old child's in that condition and that infant is in a diaper for 10 to 14 days, not bathed, not fed. You obviously are able to do it with one and not the other one. Thoughts?
Yeah, absolutely. And what breaks my heart is I don't think the officer was asking the right questions of him. I couldn't hear it real well, but I wasn't impressed with a lot of the interrogation or questioning of the defendant during that video. unless I'm missing something.
Yeah, you know, Gene, I think that this is like what typically happens, at least in my experience, is that the cops don't ask so many questions and they call usually, I mean, just in Jersey, the way this works,
Right.
the prosecutors or the detectives that are supposed to investigate the case. But of course, first responder, you know, information is critical. You just don't know.
And I don't know if
what
they
was
had the
running through
calls
his
of death
brain.
yet, right? I don't know if they had the calls of death
Yeah,
yet.
yeah, but although I think that let's listen to actually to the police officer as he's describing what he actually observed, and maybe that'll answer some questions for us. Okay, welcome back. That's the defendant's father. So, I mean, there is so much twistiness in this case. I mean, this is a child from what is his wife, which he's still with,
Yes.
not Cheyenne. This is his wife. The child's with his father out there in Oklahoma because the mother of that child felt, to use his words, inadequate. I can only imagine what's going on there. And the defendant didn't want to have to deal with putting the child in daycare while he was working. Yeah, okay, I guess so. And then this last little piece, he wasn't happy about changing diapers. It's just a little nuance, Linda. This was a good prosecution witness because I think it makes the defendant look horrible.
But, you know, he probably housebroke the dog, but he wasn't happy about changing diapers. It's the most ridiculous thing in the world. This is your baby, your son. Even if it's not, it's a little infant who can't take care of himself. Just think of a puppy or a cat. Obviously, Koehn can do that, but it's a ridiculous defense. It really was. It would annoy it would annoy me.
Gene,
and on defense.
let me ask you, what was the relevance of this testimony?
Well, I got two good things out of the father. You talk about the father?
I'm sorry, yeah, it was a defense witness, actually. So let me, and that's my bad. Actually, blow me over here, okay? That this was you know, my bad, Gene. I didn't look on the thing where it said who called the witness because I couldn't imagine from what I was listening to that would be a defense witness.
Okay, if I didn't see that either, but I thought there were two good things for the prosecution. One is, after Sterling was born, the father never saw the boy. I mean, if you love a child, you want to show the grandparents of the child the boy. That struck me a little bit. And also, Zach is OCD. He comes home, he's complaining about dishes not being washed. Yet the baby, Sterling, is sitting there. He hasn't been changed in like a week. It shows this. He wanted that child dead. He wanted the child out of his life. That witness, his father, was not good for him.
Linda, I think you were probably as blown away as I was when we just learned from the producers and the earpieces that this was a defense witness. You are a phenomenal defense attorney. You tried a lot of high-profile cases. Please, Linda, put your defense lawyer cap on, stretch your brain, because I know you're going to have to do it, and tell me, what value was this witness for the defense?
The only thing I can think of is to put somebody who is loving, who cares for his other child on, to show that he comes from a loving family, therefore he can't be a heathen in any way. But, boy, I tell you, this was not good.
Yeah, and there we go back to that picture that we see on the screen right now, Gene, with holding that 2-month-old baby. Well, right next door is the 4-month-old who's is just brutally, if you ask me, neglected and dies. I can't, again, get why the defense would put somebody on to say he doesn't care about his other child, he gave up his other child, he's still married to another woman, he's complaining about the dishes not being clean, as you've just indicated, he doesn't really like to change diapers. Gene, stretch your lawyer hat and tell me, what did this do for the defense? I mean, to me, this is a prosecution dream.
I'm stretching it here. Linda's right. I'm stretching it here. What I think they were trying to get out, the defense, is Zach is, and I'm just making an argument here, Zach is responsible. He realizes that the significant other he's living with cannot handle this little 3-week-old boy. So he is making a responsible parental decision. I'm going to remove him from our home, give it to my father, and let them raise the child. That shows that he has compassion, and it shows he's caring. That's the argument I think they were trying to make. My complaint is I don't think that father was prepped properly, okay? You go back to the Gene Rossi war room, I prepped witnesses constantly, 5 times sometimes before I put them on the stand.
Gene, I need a one-word answer from you. In that Gene Rossi war room, if I swabbed it right now, is there going to be some blood on those walls?
Maybe some saliva.
You shouldn't answer. You shouldn't answer
Yeah,
that, Gene. You need a defense attorney.
Because those
Put them
war
on the-
rooms can get awful hot sometimes when you're working on a case. Gene, Linda, thank you so much. We're
thanks.
going to go to a break. We'll be right back. Welcome back. Okay, the Baptista case is still on break. We will get to that as soon as it starts. We're going over during the lunch hour, Linda and Gene, the Koehn trial, and we have. Do I have that sound in my?
Yeah,
It's like I wonder
you.
sometimes, is that just me or is that something real? You know, when you get old enough, you start to not be able to
Bob's talking
differentiate.
about is he's hearing sounds in his ears, so you can take that for what that's worth.
Yeah, and it's usually voices. It's not just sounds like that. So it was a pleasant change. Anyway, getting back to the Koehn case, we had the prosecutor's closing statements in the case. As you know, he was convicted. This was a tough defense case. We listened to the defense try to wrangle around this kind of case, but let's listen to what the prosecutor did in order to convince that jury to say guilty on all charges. Welcome back. Okay, there's not a lot going on in that courtroom right now as they're doing some logistical things, so we have an opportunity to speak, but our producers will let us know through our earpieces when we need to go back into that courtroom. We're in the Armando Baptista trial. This is the second trial. It had been severed. The elder trial was earlier. We found out from Kathy Russin, by the way, the new prosecutor, is because the old prosecutor in the elder case went to join a private law firm that specializes in protecting abused children. So good for her and good luck, because she was a very good prosecutor based upon what we had previously seen. So new prosecutors up at the plate there, Gene Rossi. We have a witness on, Pierre Margone, who is basically the prosecutor authenticating 3 cameras that he had that apparently took surveillance video. Can you go through the basics for our audience to explain why the prosecutor's asking the questions? Because I know sometimes people can find it odd, the manner in which she is asking, but she's doing the right thing.
This is a great question. Under the federal rules of evidence, under Federal Rule 901, when a prosecutor is trying to offer evidence, a tape, a gun, any physical object, they have to present to the court evidence that that item is what it purports to be. And all those questions to lay the foundation, if you will, are you want to make sure that that tape is a copy of the tape of the camera that shows the incident and what happened. So you have to authenticate it. Did you review it, sir? Was it from your camera? Was your camera operating properly? Was the time and date accurate? And you have to show that that is what it purports to be, a copy of the camera on that date and on that time. It's called Rule of Evidence 901. It's great.
Right, and of course you got to be able to show that it hasn't been tampered with. I mean, the prosecutor seems to be doing this like water off a duck's back. But let me tell you, when I first had my first trial, it was a drug case. And there wasn't anybody there to tell us how to actually put items into evidence, how to mark them for identification.
How to get that little sticker on them.
Get the sticker on and how to break it down. I mean, so while she's doing it very routinely and matter-of-factly, she's doing it well, it is a skill set you have to learn. It's not like it's brain surgery, but you have to learn it and you got to do it right.
And you have to have every single question that makes it admissible asked of the witness.
Right, and talk to us a little bit, Linda, about, as a defense lawyer, chain of custody. And also, while you're doing that, explain that while it may not lead to the lack of admissibility, but it can be argued in front of the jury. The judge can give a jury instruction on a failure to establish a chain.
And in any case, you want to make sure that any video that is there has not been tampered with in any way, that it goes from, in this case, Mr. Marone, who I'm sure is really not happy now that he had video cameras, that he's gotten stuck in this case, right? Because that's all he did. He's just somebody with video cameras on his house. And you have to make sure they haven't been fooled with in any manner. And so you look to make sure that indeed it went from Mr. Marone to possibly the police, maybe the police reviewed it, et cetera, so that it was in their custody all the way through. You don't want this video camera going out to somebody, a third party, who may have a vested interest to change something in that case. You know, you don't want to, you just don't want that. And it doesn't really matter much in this case, but there are cases it's very important.
Right, Gene, you know, the other thing with electronic data, as great as it can be, when I was prosecuting cases, I was always concerned and put a witness on to show that there was no tampering with digital files or things of this nature, because you do hear this kind of thing happening where things can be tampered with easier than it used to be with a digital record. And I think it's important to have a forensic specialist say, I looked at it and find no evidence of any kind of tampering. What are your thoughts?
Well, in District of Columbia, there was an FBI agent who was addicted to heroin. And when he took heroin from a search warrant, whether it was a house, a car, he tampered with the evidence and he put the heroin up his nose. So there were a lot of cases he testified in, and the chain of custody went out the window. And I don't know if there was a mistrial granted or a new trial granted, but it does come up. There's a famous case on chain of custody, the O.J. Simpson case. A lot of the questions were, was that blood evidence properly cared for? Was it tampered with? Who was it? Mark Furman. Did Mark Furman tamper with the glove? Did he tamper with the blood?
Gene, awesome. Sorry to cut you off, but something's going on in court. We got to get to it. We'll be back. All right, welcome back. So this officer is testifying about, in the Baptista case, is testifying about the conversation that the victim's girlfriend had with him. Gene, the defense lawyer's cross-examining here, basically bringing out the idea that Knight exited the vehicle, his vehicle, approached Baptista's vehicle, and then a fight started. So he's basically trying to go back to that theme, that this makes no sense and that it was the victim that was pursuing the defendants, not the other way around.
Absolutely. That is the best argument. He's behind their car. He honks. He gets out, and he goes to the driver's side. This suggests what was kind of brought out, that he was at that party to be a muscle and to cause trouble, and it doesn't fit the prosecution's case. That's the theme of the cross.
Now, okay, so we've beaten this bad boy up, you know, back and forth in terms of what this case is about, and I agree with what Gene says. But Linda, talk to us about the fact that even if a juror says, look, let's be honest, like Gene said, this was kind of a setup. The two defendants left first. The victim goes pursuing them, looking for a fight. Talk to us a little bit about self-defense and stand your ground. It just doesn't give you a right, if you're starting a fight, to kill somebody.
No, it doesn't. But I don't think this defendant asked for a stand your ground hearing, which in Florida a judge can, and I could be wrong about that. You guys out there in the chat room know better than I. I think Elder had.
Yeah, but why would one do it or not do it? Let's talk about what it is.
Because you have a right when you feel threatened to stand your ground and not back off in a public place, which is different in the law now with these stand your ground laws versus the way it is, for instance, in New Jersey, which you can only stand your ground in your home, or else you have a duty to retreat. So there is no duty to retreat here when they come up to
But still, you have to confront either defending yourself or others from either serious bodily harm or death.
Absolutely. But the one thing I do want to bring in at this point, because it does go to this, the cops made a decision that indeed Baptista was not defending anybody, that he was an aggressor, because they went to him about 2 weeks later and they said he had a cut on his elbow and a cut on his lip, right? So they said he couldn't have been defending himself under whether stand your ground or anything, and yet they didn't look. They said it was nothing on his head, but they didn't bring him to a medical facility. They don't know if he had yellowing bruising from being hit by a beer bottle. They did not do that, and they waited too long.
Yeah, Gene, to Linda's point there, I always used to say, and I don't know if you've ever heard this axiom of the law, when there is a barroom fight, let's say, for example, or a fight over a girl in the typical scenarios, the guy on the ground is called the victim, and the guy standing up is called the defendant. When in truth, it may have been the victim that was the aggressor, and the guy standing up just happened to be a better fighter.
Absolutely. And here's the other thing. If I slap somebody or spit on somebody, you can't take a knife to my throat. Your response to the force that you reasonably see has to be proportional. So if I'm just trying to push you or slap you around, you can't take out a gun and a knife and kill me. So that you have to have proportionality.
Right. Excellent thing. It has to be reasonable. And so we'll go around this case. It's being tried a little differently than the first case with the Elder case. And we're going to go to a break, and we'll be back with more of the Baptista trial. Welcome back. Okay, Baptista is still slow in that courtroom. They're going to let us know when something's going on. Off camera, for some reason, Gene Rossi keeps telling Linda that he loves her glasses. I don't think they look good on you, Gene, but you know, who knows?
I'm inviting Gene to come to your show.
Yeah, he said
Right?
next time he's in New York, he wants to wear your glasses. I don't know what's going on with the glasses. I don't want to. Maybe I don't want to know. Anyway, going back to the Baptista case, Gene, let's talk about, as prosecutors, this idea that when you come on to these mutually combative fighting scenarios, it can be very difficult to pick and choose who are the people that should be prosecuted, who's the victim, who's the defendant. And I want to talk to the audience a little bit about crime scene investigations. I'm sure you've been intimately involved in, and confirmation bias. I have actually seen cases where they go to the scene, they say, there's the bad guy, there's the victim, and despite any piece of evidence to the contrary, once they make up that decision, they hold on to that ghost and they don't let go. Have you experienced that?
Oh, yes. That's what a show up is. That's what a lineup is. You think you have the right guy and you want to confirm your gut feeling. And it's a terrible thing when detectives go to a prosecutor and they tell the prosecutor, we think it's this guy. That prosecutor has a difficult hurdle, because if you, the prosecutor, don't think it's the right guy, you got to persuade 4 or 5 detectives or agents that they're wrong. And that can be a very difficult conversation. It doesn't happen a lot, Bob, but it does happen.
Well, I've seen this, Gene, in my experience. Like you're bringing up something I think is so fascinating for the audience. You have the legal side in a prosecutor's or a prosecutorial agency, and the cop side. And sometimes the two just don't, you know, I used to call it kitty boo-boo. It can be a lot of kitty boo-boo. The lawyers typically want more evidence. The statement's being taken, I mean no disrespect, it's just a little friction that goes on between the two. But the lawyer's thinking about what I'm going to confront at trial, what defenses there could be. I need more evidence. I needed to go back and get more of a statement. The guy talked about how angry he was. That could be a passion provocation defense. I need you to button that down. And there can be a little bit of that resistance that goes on where like, these lawyers, they're crazy. Yes?
Yes, and you know what? I think it's in the articles that we read. The grand jury dropped the manslaughter charge, the murder charge to manslaughter. And then on the other guy, I think it was Elder, they dropped it. The prosecutors made the decision to drop it to manslaughter. So even the grand jury had a problem with this case against Elder and Baptiste. And when a grand jury has a problem on a charge, you are looking at a hung jury or an acquittal.
Well, Gene, to Linda, to the point that Gene just made, I have presented probably thousands of cases to a grand jury. You were a former assistant prosecutor.
Right.
I cannot think of a time where the grand jury did not go along with what it was that we wanted to have done.
That's right.
And in this case, that's a substantial departure that Gene just mentioned.
Absolutely. I never remember what we would call a runaway grand jury, which someone didn't go along with what you wanted done. But to Gene and your point, we've all had it. I had a case before there was DNA where the cops insisted that this man raped a young woman, right? Insisted. But when the labs came back, it showed it wasn't him. It couldn't be. And finally, I got through to everybody, like, I'm dismissing them. They said, well, you go talk to the victim. They were intense and intent and zoomed in on this guy, and then no one was ever found.
Linda, you know, when you run an agency, you get a whole different perspective because you're responsible for every investigation, not just a unit,
Right.
sex crimes, homicide. I can tell you on a number of occasions, but one in particular, within 15 seconds, because the female victim of a homicide was going through a nasty divorce. The husband became a person of interest, understandably. They were like, he's the one who did it. There's divorce papers all out here. He was in the area earlier that day, blah, blah, blah. And they were disregarding and discounting, like, I was just a common sense part. Like, well, who is this kid that was there? The last person in the morning was with her. He was there around lunchtime checking in around her door, and doesn't make sense that he would be there. And when the cops finally respond, there he is again. And like, no, we cleared that guy. He's fine.
Right.
Well, I'll fast forward. That guy's serving life in prison right now, and that husband has no idea how close he came to getting locked up.
And you know what? It's a problem that's existed for years. Charles Dickens, who wrote in the 1800s, wrote about this. That
Yes.
once the cops, absolutely, Gene knows, once the cops zero in on somebody, they do not let them go. I think they were called then, what, the Bow Street Runners?
Yes.
Gene? Yes.
Well, you know, you get it all here at the Long Crime Network. I mean, we were doing Shakespeare. I think, Gene, we were talking about that. Now we're doing Dickens. So we like to interfuse all of this stuff in our legal piece. But, Gene, going back to that confirmation bias, I've also found prosecutorial bias when it comes down to the idea that you could present copious amounts of information to say, well, he may have done it, but let's work this case out to something less than what it is that you originally offered, and there's just a no, you either take it or leave it mentality. Thoughts?
Oh, could you repeat that question, Bob? I didn't hear the beginning.
Yeah, I'm sorry. I'm hearing from our producer something. Let me just make sure I understand what's happening. Okay, Gene. The question was, prosecutors sometimes can have confirmation bias. When they've made a plea offer, you then present a lot of mitigation information, maybe drug or mental health history. You're not saying the guy didn't do it. You're just saying, look, let's get to a more reasonable, balanced, measured plea offer in the case. And many prosecutors will do that, but boy, you get some that are just like, that's it. I made an offer, and there's nothing you're going to do or say that's going to change it. Take it or leave it.
Okay, I was the prosecutor that always wanted a deal. And even if I thought the defendant was guilty of sin, if they're willing to plead to something that's reasonable and proportional, I'll take a guilty plea any day of the week, because you don't have a trial, you don't have an appeal, and you can move on to the next case. I did have people in my office, and they're still there, who were Attila the Hun. My way or the highway, I'm not going to plead it down. And you have some prosecutors who say, if you're indicted to something, you either go to trial or you plead to the indictment. That's not how I roll.
You know, and Gene, that's not how I rolled either. And I think, first of all, you don't have to have been a defense attorney. But I will say, when I was a baby prosecutor, I remember getting in an argument with a defense lawyer because the client was pleading guilty to like 30 burglary cases. It was a juvenile case. And I wanted him to plead guilty to every single offense. And the guy's like, you won't even dismiss burglary tools? And I was like, no. And the guy threw his file down. He's like, this is ridiculous. Listen, I learned from my superiors, Bob, it's a give and take scenario. I learned from that. I was trained. I was tutored by people how to be measured and how to be balanced, both in the plea and the sentence. But I agree with Gene. There are some that you confront. They've never been defense attorneys. They've never seen the other side. They're all, you know, all to the walls,
they don't have to run a budget.
Well, yeah, and there seems to be, I talked to my dad about this, who you guys both know, a lack of a little mercy and compassion. Take a little zip off the fastball. We can all accomplish deterrence and punishment with mercy and compassion and move on to the next case. Thoughts?
Yeah, no, absolutely. I was a prosecutor also, as you know, and we've all been there, and you really have to roll the punches. You have to see what's good for the victim, what's good for the defendant, what's good for your office. You may have a case that you need to devote a lot of resources to coming up. And it's not that it's a victim in the previous case deserves less resources, but you know if it's a burglary or something, you know that if they plead to 1, 2, or 3, or 4, they're going to get the same time from the judge because the judge is aware of the other 4 burglaries. So you take the plea.
Right, right. I think, Gene, I don't know your experience, 3 decades, but when I was being trained as a baby prosecutor, I had powerful people, including judges, that talked about the philosophy of criminal justice, the philosophy of balance and reason. I don't see that anymore.
Well, that's not how I taught people. And when I prosecuted, I thought of several things. One, is this charge they're pleading to, is that the right charge for the crimes he committed? He may have committed 7 crimes, but if he pleads to 2 of them, is society served? Is he getting the message? Also, costs. It costs a lot of money to prepare and try a case and work on the appeal. The cost to society. And the last thing is, you always worry about the victims. What do they want? And sometimes you have to tell them,
Gene,
you're not getting, yeah,
you're not going to get what you want, Gene Rossi. Costs, I agree with, but we got some costs. That's why we got to go to a break. Hard break. We'll be right back.